Doubles and coffee. Just before I go to bed to put on my suit and thing and go in the Senate to debate two bills, the pension amendments to the Pension Act, Prime Minister's Pension Act, and the mid-year review, the appropriation, supplemental appropriation bill. I just was doing some research, so I just read it for you all. And in the words of Bob Marley, Robert Nesta Marley, the greatest of all time, who the cap fit, let them wear it. In law, a conflict of interest, a COI, exists when a person or entity has multiple interests, often financial or personal, and serving one interest could potentially compromise or negatively impact another. The situation typically involves a duty to act in someone else's best interest, which is then potentially undermined by a competing personal interest. Essentially, a conflict of interest arises when an individual's personal interests clash with their professional or fiduciary obligations. Let's break it down some more. Competing interests. A conflict of interest involves the presence of two or more interests, financial, personal, that are in conflict. One interest could potentially be harmed or compromised by actions taken to benefit the other. Duty versus interest. A common scenario involves a person having a duty to act in the best interest of a client, employer, or the public, while also having a personal interest that could influence their decisions. The existence of a conflict of interest is an objective fact, not a matter of someone's state of mind or intent, even if someone doesn't intend to act unfairly. The potential for harm is there. Examples, I won't give you all, but let's just give you one. A public official making a decision that benefits their family member, even if it's not in the best interest of the public. Disclosures and recusals, for example. In many legal and professional settings, individuals are required to disclose potential conflicts of interest and may need to recuse themselves from decision-making processes where a conflict exists. The impact. Conflicts of interest can undermine trust, damage reputations, and lead to unfair or biased decisions, potentially resulting in legal and financial consequences. Individuals are required to disclose potential conflicts of interest and may need to recuse themselves from decision-making processes where a conflict exists. Now, let's also talk about apparent bias, the standard. You see, people like to concoct rationale and emotion when it comes to politics. When apparent bias, conflict of interest, these are simple principles that have been dealt with by the court. Impartiality and independence. The need for impartiality and independence is sometimes also known as the rule against bias. Bias can be generally split into three types. 1, actual bias. 2, presumed bias. And 3, apparent bias. Actual bias refers to the situation where a decision maker has actually been prejudiced or been affected by impartiality in coming to a decision. Like probably having been a lawyer on a case that was fighting for one side in one argument, and then coming to a position in a different sphere to have to vote on whether the other side of that same argument was making sense. Very interesting. Presumed bias. refers to a situation where the decision maker is disqualified due to the inherent interest which the decision maker may have in the outcome of the decision, such as shareholding in a concerned company or being the judge of a family member or member's case. This would exist even if the decision maker was willing and able to act impartially. Maybe somebody earns a lot of money when one side is in charge. They get a lot of information, briefs, consultancy fees, stipends for being on boards. These things lead to presumed bias. The next bias is apparent bias. Apparent bias is the most commonly referred to ground of bias, which exists if a fair-minded and informed observer, having considered the facts, would come to the conclusion that there was a real possibility the tribunal was biased. See Deacons versus White and Case, and also Hacker versus Emrad Hussein. Many cases, but the principle is simple. So who the cap fit, let them wear it. But don't pretend and read fake news media and concoct all sorts of arguments which do not make sense. Get away from the basic principles of propriety, righteousness, fairness, equity, and just pure courtesy and brought-up-see. If you have a conflict, you have a conflict. There are certain jobs, for example, that I could never apply for with a good conscience and heart. I cannot apply to be a judge in a political matter or on a tribunal because I am a UNC and proud and believes, and I can't just shake off that. I can't shake off the gospel of the UNC. I believe in it. I believe in the philosophy, and therefore, even if I intend to act impartially with all my might and my intellect, I suffer from apparent bias, even if I don't take it to actual bias, and therefore I could not adjudicate in a tribunal or arbitrate in a matter involving a UNC versus a PNM. I cannot. End of story. If I am UNC and I work hard and I get a job from UNC or the UNC PRO and I get opportunities to serve the country and earn a salary and a stipend, I cannot then sit and say I want to independently arbitrate between an issue between the PNM and the UNC, because I, Anil Roberts, whether I am intentionally going to do so or not, whether I am going to be as fair-minded as possible, read the facts, because you all even know, even though I detest Rowley, I detest Stuart Young, I detest the PNM and the oppressive ways, never once in one of these videos have I ever told an untruth on them, lied on them. Everything is factual. So even though I am totally biased against the PNM because I disagree with their philosophy, their rich get richer, their recusals, their usurpation of independent institutions, their decimation of our country, our national fabric, our tapestry, the racist policies of division and discrimination, even though I am passionately against the PNM, not 1 second have you ever heard me lie on Rowley, Smallpin, Imber, or any one of them. So I'm able to deal with things impartially based on fact. However, I am still conflicted. I still lose or cannot muster to overcome the standard of apparent bias, because I am biased, because I am UNC and proud. It's that simple. So if you're getting briefs from the PNM, then you're suffering from apparent bias. If you was on a PNM board, then you're suffering from apparent bias. Even being appointed to a committee, for example, by a PNM. So when you come to say the TTRA would be appointed by Colin Imbert, the Minister of Finance, the board, that in itself, it does not muster also pass the test for apparent bias because you were selected by the PNM to sit on a board. So when people making an argument about the TTRA board, the law lord said it should not suffer from political interference or bias. That's the principle. Now, when you know PNM, and you know who PNM puts on boards, they put their own personal lawyer, they put a neighbor from Inez Gate, they put rabid PNM like Ingrid Lashley on 9 boards. You understand that once you are appointed by a PNM, you are biased. Actually, apparently, conflicted, you are biased. So therefore, the board of any TTRA to go into people's taxes would have been conflicted, would have been biased towards the PNM. That is how it is. Once you preach the gospel of the PNM, you cannot appoint independent-minded people to take a decision involving PNM versus UNC. It's an impossibility. It's illogical. It's asinine to try to suggest that. Just read the simple principles of conflict of interest and apparent bias. That's all. Bob, sing it for me, boy. Who the cat fit? Let them wear it. Bless.